A YouTuber has revealed the identities of the men involved. The man shown in the video is identified as one of the main perpetrators in the Milyang middle school girl rape case. As public outrage grew and criticism poured in, the famous restaurant where this man worked eventually shut down. The restaurant owner posted an apology note stating, "The identified man is indeed my nephew and apologized for the social disturbance." Another company, an import car dealership where another man identified by the YouTuber worked, released a statement saying the man was fired. Besides these two, another man identified by the YouTuber faced suspension and reassigned at a major telecommunication company. Why is this happening? Shockingly, these men were perpetrators who gang raped a middle school girl 20 years ago in Milyang, Gyeongsangnam-do. The number of perpetrators who raped the girl totals 44, and including those who indirectly participated such as lookouts, the number reaches 119. However, only 10 were prosecuted and all were sent to juvenile detention, leaving no criminal records at all. At the time, the lenient punishment sparked immense controversy. Now, a YouTuber has emerged revealing the identities of these perpetrators, gaining immense support from the Korean public. In 2004, 44 men gang raped a middle school girl around 14 years old over a year. Senior and junior classmates from the school around Milyang met the girl online, assaulted her, made her unconscious, gang raped her, and filmed the act to threaten her. Despite the horrific crime, the perpetrators acted arrogantly during the investigation. Families of the perpetrators threatened the victim and her family, saying they should be worried about future repercussions. One parent of a perpetrator fueled public anger further by saying in a media interview, "The girl should have been raised better. She seduced them first. We are wrong." Ultimately, none were criminally punished. Most were sent to juvenile detention, leaving no criminal records. The boys threatened to distribute the footage if the girl reported them, but they escaped criminal punishment. The victim continues to suffer from depression and social phobia, while the perpetrators live well, leading to ongoing public criticism. This long silent anger exploded when the YouTuber exposed their identities. Most men whose identities were revealed have been fired or resigned from their jobs. A woman who mocked the victim and supported the perpetrators on social media during the case is now a police officer at Uryong police station, facing a deluge of complaints on the station's website. She issued an apology saying she regrets causing pain to the victim and her family and will bear the burden for life. The YouTuber plans to continue revealing the identities of the perpetrators, suggesting the fallout will persist. So let's examine the legal issues surrounding such private sanctions. Yes, you can be punished. In South Korea, even if the facts are true, disclosing them can still be considered defamation if it damages someone's reputation. Therefore, even if the YouTuber revealed the criminal facts, they could be subject to punishment. However, if the disclosure serves the public interest, the court may not punish it. This is why media outlets that expose corruption are not penalized. Some argue that the YouTuber who revealed the identities of the Milyang rape perpetrators should not be punished for contributing to the public interest. However, publicizing defamatory facts for the public interest is only allowed in limited cases. Media outlets follow reporting guidelines and ethics, which is significantly different from an individual YouTuber disclosing allegations. Additionally, individual YouTuber disclosures often spread unverified information, leading to other victims. For instance, one man lost his job after being wrongly identified as a Milyang rape perpetrator, only to be later revealed as merely a friend from the same school, not involved in the crime. In short, because they were minors. In South Korea, crimes committed by those under 19 can be subject to juvenile protection measures instead of criminal punishment. These measures range from parental supervision to community service to juvenile detention, but they do not result in a criminal record. The idea is to prevent a criminal record from becoming a lifelong obstacle for young offenders. The prosecutor, police, and the court handling the median case sent all 44 perpetrators to juvenile court or cleared them of charges. They acknowledged the sexual assault charges but deemed criminal punishment unnecessary. While the intent of the juvenile law is valid, the publicly available verdicts show that the 44 perpetrators committed heinous acts that warranted criminal punishment. Well, this leniency in such a severe case is what outrages the public. Yes, annulment, cancellation is possible, and so is divorce. The most common ground for annulment is marriage by fraud or coercion. For fraud to be grounds for annulment, the deceit must be so significant that the marriage would not have been occurred otherwise. Therefore, if the spouse's criminal record would have prevented the marriage, it qualifies for annulment. Proving the significance of the deceit is crucial in this case. However, annulment must be sought within 3 months of discovering the fraud. If this 3 months period is missed, divorce can still be pursued if the trust in the marriage is irreparably broken, constituting irretrievable breakdown under civil code. This is your attorney, Jiwon Lee. Thanks for watching.